Well, hi everyone, morning, and a very warm welcome to BDB Pitmans employment webinar on what happens next now that people are returning to the workplace. For those of you who don't know me, I'm Nick Lariche, one of the partners in the employment team, and I'm delighted to be joined by a super panel of speakers today who will each be looking at a different aspect of the return to work process. In July, we kicked off our new Pathfinder program, in which we discussed the issues that organisations needed to consider in order to shape their businesses to deal with the challenges and opportunities provided by the new world of work ahead beyond COVID-19. This morning is our next in our series and will give us an opportunity to explore this topic in greater detail. Yesterday, London Underground had its busiest morning before the first lockdown, and in other parts of the country, there's been a gradual increase too in commuters in the last few weeks. Certainly walking over London Bridge this morning, things seem to be a bit more back to normal. But despite these signs, there remains a great deal of uncertainty over how the transition to greater office working will pan out, and a wide variety of new and different challenges for employers to consider. In a moment, I'll hand over to Laura Binney, who will look at how to manage new working patterns and how to protect against potential discrimination claims that could arise out of hybrid working. Laura will also look at the question of salary levels for staff who want to continue to work remotely, a topic that has hit the headlines a lot during the summer. Aston Hawkes will then consider the very thorny issue of how to deal with staff who don't want to return to the workplace at all, and the practical tips you can bear in mind in dealing with these type of issues. She'll also look at what the end of the furlough scheme might mean for employers, and finish her section by looking at another headline-grabbing issue of the last few months, compulsory vaccination policies, and what you need to think about if you're planning on introducing one. This topic not only throws up employment issues, but data protection ones too. And Alexia Elisardi will take us through the key points to help make sure that you stay on the right side of the ICO on not only vaccination issues, but COVID-19 generally. Before I hand over to Laura, I just want to cover a couple of housekeeping points. At the bottom of your screens, you'll see the familiar Zoom functions. And in particular, I'd like to point you to the Q&A button. This is where you can ask questions about what we're talking about today. And we'll try to deal with these at the end of each segment and some at the end of our session, especially where there have been particular themes or points that have come up in common. If there are questions which we haven't had a chance to answer during the hour, then we'll post the answers together with today's slides and a recording of the webinar on our website, and we'll share a link with you. But I'm hoping we'll get through a good number of questions today. The chat function can be used if you're having any technical difficulties during the webinar, and Melissa and Katie will do their best to answer these. I think these are all the main points I wanted to cover. So thanks again for joining us. I'll now hand you over to Laura.
Hi, good morning, everyone. Thank you for joining us. If I could just have the first slide, please. I'm Laura Binney, and I'm going to be covering, as Nick said, three distinct areas this morning under this umbrella heading of returning to the workplace. So first of all, new patterns of work, as Nick mentioned, and how we see those sort of fitting into the post-COVID world. Then I'll come on to talk about discrimination risks that will possibly arise from hybrid working and how you can think about managing those. And then I'll come on to the sort of fairly interesting issue of salary levels in the context of remote working. So basically whether someone's place of work can actually affect what they get paid. So coming on to the first slide of mine, please. Thank you. So how will working patterns need to adapt to the new normal? As we mentioned in our introductory webinar to this Pathfinder series a couple of months ago, each business is going to have its own priorities and its own approach to this issue of how and where they would like people to work coming out of the pandemic. So there certainly isn't any kind of one size fits all that we can kind of point you to. But it's fair to say that, of course, you know, the last 18 months now have had a major impact on the way that employers and employees view working patterns and working arrangements and that level of flexibility that's kind of been introduced. So for a lot of businesses, not all, but for a lot of businesses that we're seeing, certainly, there is going to be, I think, a shift to, adapting to a different kind of working world. So in terms of COVID and the current position, employees are no longer advised by the government to work from home where possible. So employers are free to be planning their return to workplaces, and many have already been starting to do so. I think that probably going forward, some degree of flexibility is going to be commonplace, whether that's location, hours, the introduction of hybrid working policies. But what that sort of actually means in practice and how you sort of go about implementing those kind of flexible patterns is what's going to be key, I think. And as employers, you'll need to be quite clear about your expectations and justification when thinking about this. So, for example, what are your business needs? Do you require everyone to return to the office straight away? And if so, why? It's fine to sort of, as long as you've thought about it and got an answer to it, that's the main point. What percentage of time will be appropriate to spend in the office? That's very much a question that depends on your business needs, the type of role involved, the industry. Is this a job that's a client-facing one? If so, where does the client want you to be? Very much sort of ultimately what your business is comfortable with. There really isn't a right or wrong answer here, I don't think. As long as you've kind of considered the points and have come up with, a considered response, really. And I think it is quite important to mention that, there isn't any sort of legal requirement to sort of change previous working patterns. It is a popular approach that we're seeing to sort of think about a hybrid model, but it doesn't mean that there's any sort of legal requirement for you to do so. The law itself hasn't changed, so it's very much what suits your business needs. So there are all sorts of different considerations you might want to think about, whether you'll allow a sort of phased or gradual increase in the number of days spent in the office, and perhaps also what you're looking at what others in your particular sector are doing to ensure that you remain competitive, especially when you're thinking about recruiting new talent. So whatever kind of working pattern that you do go for, it should be sort of well thought out, it should be well drafted and communicated effectively. So remember that you might well still be dealing with people who are anxious for whatever reason about returning, or people who are just maybe a bit unsure generally about what the next stage really is. So you'll need to, just sort of manage those kind of concerns, and Aston will come on to talk about that in a little bit more detail shortly. So in terms of implementing new patterns of work, the most common approach that we're seeing is to introduce a policy, such as a hybrid working one, if that's what you're going for, that will then set out what you expect and contain some boundaries. It can then be amended as time goes on as you see fit. Can even be withdrawn if that's what you choose. So it's really just important to kind of get your message across in that policy. You could go for a contractual change if you wanted to, but that's going to be a bit more of a formal process, although you could kind of contain a trial period within that clause if you wanted to, and we've done some drafting along those lines if you wanted to think about that. But practically, once things are in place, how will these working patterns adapt to the post-COVID working world? And I think that's very much an answer that is a sort of time will tell one. Most people have had a fairly considerable period of time away from their normal workplace environment, so it's pretty sensible to expect there to be a period of adjustment as people return. And I think allowing for that period of adjustment is going to be helpful, and that's going to sort of foster positive employee relations effectively, happier staff and more productive staff. But a couple of things that you might want to think about in terms of these new working patterns, especially if it is a kind of hybrid model that you're going for, is making sure that there is some crossover of days in the office, not just with primary team members, but across the wider organisation as well, so that people do see as many colleagues as possible. and also sort of inbuilding some flexibility into your policy if you've adopted one. So, you know, it will be reasonable, for example, to ask employees to come into their office space on short notice if there's a particular reason to do that. I think, you know, the flexibility probably needs to work both ways for it to work well in practice, and for these kind of working patterns to sort of have a positive effect, I think. So if I can come on to the next slide, please. This is potential new discrimination risks. It's sort of linked to new working patterns, and because we are employment lawyers, we like to think of potential claims that might be on the horizon or that people can potentially raise. And I think the main thing for businesses to take away on this point is, you know, with these different kinds of working arrangements that are going to be in existence, there is an associated risk of people claiming that they've been treated differently. Nick touched on this briefly in our introductory webinar, and essentially it may well be that more people with certain protected characteristics, such as sex or disability, will work on a hybrid basis, or may just do so more often in this new working world. So if, for example, you have a working parent who happens to possibly also be female, or you have someone with a disability, and those people are working more flexibly to accommodate their circumstances, then they might well be able to raise some valid concerns if they are then treated differently when it comes to opportunities such as promotions or bonuses, training, even the quality of work that they're being given, anything really, if they can compare themselves to some others who are more office-based. I think it's just, you know, that kind of indirect discrimination risk is a real one to sort of be aware of. We're yet to sort of see how that will obviously kind of pan out in practice, but thinking of your equality policies and treating staff fairly regardless of where they do their work from is going to be really important to sort of avoid those kind of complaints, or at least be able to defend them. I've mentioned disability issues on the slide, and that's not really just in the context of hybrid working alone, but perhaps the sort of more wider post-pandemic world. I think there are a range of conditions that might well be on the increase, whether that's mental health issues coming out of the pandemic, or just possibly a rise in more sickness absence generally as a result of people, you know, returning to mixing again. It's always worth considering whether an illness might amount to a disability. You know, it's usually the more sort of long-term ones that are an issue, but, you know, the definition is wide, and you know, it's a day one right, like all discrimination ones that people can rely on to sort of at least bring along this argument that, you know, they have been treated differently, effectively. That also links to this sort of question that we're seeing about whether potentially long COVID might amount to a disability, which I think will probably be tested at some point, and each case will very much depend on its own facts as to how serious the condition is for someone. But I think there is a lot of evidence now to show that, you know, potentially it does have a serious adverse effect on daily life. And then, you know, if again, it also meets the test of being long term, so it's either lasted for 12 months already, or it's likely to last for that long, then, you know, I can certainly see that that's going to be a new area that is ripe for these kind of potential disability discrimination allegations to be brought. You know, if someone who's got long COVID has got some treatment that they're complaining about, whether that's you know, by way of a grievance or something that might be, you know, involved in a restructuring or redundancy process. It's the sort of arguments that we might see coming up in the sense of a new disability, effectively. Doesn't necessarily mean that a claim is going to succeed, but as an employer, you will need to sort of deal reasonably with those kind of situations. Think about, you know, whether there are reasonable adjustments that are going to be suitable for disabled people to be able to come back to work. And also just, you know, considering the possibility of home working as another adjustment, which is something that I think might be used, you know, more than ever before, given that people have been able to rely on it working for a fair bit of time. Run with any kind of situation where someone's alleging less favourable kind of treatment, then you need to consider those kind of allegations in the context of your equality policies that you have. And any sort of indirect discrimination will, of course, be unlawful unless you've got a defence by way of showing that, you know, the treatment involved was pursuing a legitimate aim and it was a proportionate means of achieving that legitimate aim. So just a couple of things to think about that might arise from this new world of working. If I could just come on to my final slide. We thought that we would just mention the subject of salary levels for those who are working remotely, whether that's some or all of the time. And it's yeah, something that's you know, been in the media quite a bit, and so you might have already read a little bit about it. So essentially, it's thinking about whether those in high earning areas such as London should be receiving their same weighted salary if they're not actually working from that location. So I think the classic sort of argument about it is in favour of salaries being reduced is that, you know, otherwise we might all choose to go and work and live from Cornwall or indeed anywhere else in the world, while still receiving the same salary that, you know, a big city typically commands. I don't think it's sort of as straightforward as that, and it's got various legal kind of complications with it, not least because, you know, such a fundamental term as salary is going to go to the heart of the contract and will need generally consent to sort of change it. But if you are thinking about it, I think one of the considerations is to think about the extent of home working. Are you talking about a job that's being done completely remotely 100% of the time, or is there a bit more of a mix of home and office work? If it's the former and it's a job that can literally be done from anywhere in the world, then I think you know, there is going to be a potential argument that salaries can be adjusted if you as an employer are agreeing that that job doesn't need to be done from an office base anymore. Then, you know, an adjustment can be discussed. Think about who is requesting that location change, because I think if it is done by way of a conversation with an employee who is requesting to work completely remotely, and pre-pandemic they were office-based, then I think those kinds of conversations, you know, will happen, and there isn't really a reason why salary adjustment can't at least form part of that discussion if everyone agrees. But equally, I think those scenarios might be a little bit thin on the ground, because if you are looking at staff who are on a more flexible working pattern, where there is a requirement to still come into their office space 1, 2, 3 days a week, or whatever it might be, then I think something as drastic as a salary cut is probably going to be much more difficult to justify. You're then in a situation where the employer agrees with some level of remote working anyway, and then is expecting an individual to come into the office for the remainder of the time. So, you know, they're then unlikely to be able to live very far away. They'll probably have similar living and commuting costs. And the subject of salary reduction is probably going to be quite a risky one, especially if you're dealing with existing staff as opposed to new ones. There's also, on the face of it, some potential discrimination risks or even equal pay arguments if you are paying remote workers differently to those who are office-based, yet they're doing exactly the same work. Some will point to the fact that people are still incurring different costs if they're working from home, with heating bills, broadband bills, and general house costs. So it's a bit of a tricky situation. I think, like many of these issues, there will be a benefit in waiting to see how things pan out. We might have some guidance or some cases on it at some point. It remains to be seen whether the subject might come up by way of thinking of redundancy situations, and an alternative to redundancy could be a salary discussion. But for now, I think, you know, unless you're having one of those kind of conversations that I mentioned at the start, it's probably more useful to concentrate on enhancing employee engagement over the next few months, certainly, rather than thinking about changing their pay. But it is something that you can be considering, and we can provide some advice on that if you wanted to be thinking of that road. But for now, I think I'm going to hand over to Aston, who's going to take you through another few areas today.
Thanks, Laura, and good morning, everyone. So I'm Aston Hawkes, and as Nick mentioned, I'm going to talk to you about a few different return to work topics this morning. So the end of furlough, staff refusing to return to work, and the issue of compulsory vaccinations. So if I can have my first slide, please. So the first thing I want to talk to you about is the end of the coronavirus job retention scheme. So 19 months since it was first implemented, the scheme is starting to wind down and will come to an end on the 30th of September 2021. So what are the implications for employers once it does come to an end? So firstly, probably one of the most obvious impacts of the end of the scheme is the support in respect of employees' salaries. So though the tapering effect of the government's contributions to wages under the scheme was intended to prepare employers for the inevitable end, it will without a doubt still be a shock to the system for employers who will once again need to account for the entirety of their employees' salaries once again. It's important from a business perspective to assess the financial viability and workflow of your business going forward, as well as the need for any reduction for staff and plan accordingly. If financial viability is a concern, there are a number of options that an employer might consider. So employers could seek to reduce payroll costs by implementing a pay reduction for a set period of time. As with any contractual change, consultation and consent would be needed, but if an employee refuses to consent to that contractual change, then you could impose the change unilaterally or terminate the existing employment contract and offer employment on new terms. Both of those latter avenues attract various risks and so should be approached with caution. For example, you could attract unfair dismissal claims. Another option that you might explore is to seek to bring staff back on reduced hours and pay. This is likely to appeal to any employers who don't need the full-time commitment of staff immediately, but expect a return to normal trading in the medium to long term. However, the same consultation and consent process would apply to this option as the first one that I mentioned. A further action that could be explored is to ask staff to take unpaid or part paid leave. This is usually agreed on a purely voluntary basis, and such agreement should be set out in writing if you do wish to do that. Employers with an appropriate provision in their contracts could seek to lay off some of their staff or put them on short-time working, but you should ensure if you are going to use that kind of clause that you consult before you implement such a provision and provide any reasonable notice. Finally, unfortunately, sometimes the only option is to make redundancies, and if that's the case, you should follow an appropriate redundancy consultation process to minimise the risks of potential employment tribunal claims as far as possible. If you are looking to make redundancies during the last month of the scheme, there are some additional practical points for you to be aware of. So government guidance does not prevent furloughed employees from being made redundant. However, furlough grants cannot be used to substitute redundancy payments. Redundancy payments should also be calculated on the basis of an employee's pre-furlough salary, i.e. not the 80% reduced rate. Furloughed employees are entitled to notice as usual. However, employers cannot claim a furlough grant for any employee serving a contractual or statutory notice period. In deciding on your redundancy selection pool, you should also take the usual approach of identifying those employees carrying out the same or similar work, but selecting furloughed employees from the pool just because they've been furloughed runs the risk of the process being unfair and potentially discriminatory in some circumstances. So moving on to some more practical considerations, employers will be bringing back staff on their pre-furlough terms and conditions. Ideally, if you've furloughed any staff, you will have had a written agreement in place with your employees as to how and when they'll be brought back. But you should in any event write to your employees in advance of their return and provide them with reasonable notice, and on a practical level, remind them of their return to work date. In addition, many of these individuals will not have been in the office for over a year and a half, and so it's also important to consider any steps that you may need to take to facilitate their return. By way of example, you may need to make them aware of any updates to your health and safety procedures in light of your ongoing risk assessments. Similarly, you may want to change your work environments to ensure a safe place to work to the extent you haven't done that already. And you may also wish to implement some form of support for employee well-being, given the duration of times that individuals have been away from work. So this could be via a refresher induction process, some training, buddying, or mentorship, or phased returns. So in short, there will be a period of uncertainty for both businesses and employees as we navigate the employment sphere after the end of the scheme. However, the most important thing for employers to remember is that preparation and communication are key, and you should start thinking now, if you haven't already, about how your business will operate from the 1st of October 2021. So next slide, please. So on the topic of the 1st of October 2021, I'd like to talk to you next about the situation if staff refuse to return to work. This is definitely a big question for employers at the moment. So you've had staff that don't want to return from furlough, or they've been working nicely from home, and how do you get them back into the office? It's completely foreseeable that individuals will have some concerns about return to work in the office, and so trying to assuage their concerns is of the utmost importance. If employees outright refuse to work, it's important to consider the reasoning for such refusal. An employee could refuse to return to work on the basis that they believe they're in serious and imminent danger, and such belief is held reasonably. Any employee subsequently dismissed for their failure to return to work for this reason could bring a claim for automatic unfair dismissal, as well as claims for any detriment as a consequence of raising such concerns. In practice, though, employees who are most likely to hold a reasonable belief that returning to work could be dangerous are those who are either clinically vulnerable or clinically extremely vulnerable, or have not been fully vaccinated yet. However, employees may be suffering from a mental impairment, such as anxiety or stress, which could also easily give rise to legitimate concerns about their return to work and exposure to the virus. Implementing and communicating a risk assessment and its follow-up steps, which will include things like addressing ventilation and cleaning, should go some way to reducing the risks of employees being able to state that they genuinely hold such a belief in relation to their imminent danger. But you should, in any event, speak to employees expressing any concerns and try to understand and alleviate them where possible. You could also consider a phased return to work or working from home arrangement for individuals with serious concerns. If these are not possible operationally, don't be afraid to ask the individual themselves what they feel would facilitate their safe return. They may have some practical ideas which could be easily implemented. Where an employee refuses to return to work without a valid reason, the best approach is still, at first instance, to understand the employee's reluctance, to be sympathetic to any concerns, and to try to resolve them. For example, by allowing them to work from home, offering flexible working, or allowing them to take holiday or unpaid leave. Employers should ensure, in any event, that they document any decision-making process for their own records and for later reference. Unless an employee has a valid reason not to return to work, they remain contractually bound to resume their previous role with their normal place of work, albeit on reasonable notice. And so in theory, this means that an employer may be justified in following its disciplinary procedure and taking action against an employee for failure to follow a reasonable instruction or for unauthorized absence from work. But in practice, extreme caution must be exercised before disciplining or dismissing a member of staff for any refusal to return. In circumstances where an employee is clearly concerned about their health and safety or that of a loved one, then any decision to discipline them or dismiss them because of this could result in a potential claim for unlawful detriment, unfair dismissal, or discrimination. It's important, if you do decide to take disciplinary action and ultimately dismiss an individual, you have satisfied yourself that you've consulted thoroughly on the issue, investigated the reason for refusal, put in place any measures to ensure a safe workplace as far as possible, have an up-to-date risk assessment and, where possible, an individual risk assessment, and explored alternatives to a full return to the workplace working for that individual. These are factors that will be very important if a tribunal claim were to be later submitted. So in short, employers should try to be creative where possible in facilitating a return to work and make sure they consult with staff regarding any concerns and how to resolve them. If there's any business case requiring return to business working in the office, for example, for training or supervisory purposes, consider less onerous or phased ways that this could be achieved. If employees outright refuse to return, you may be able to dismiss them fairly, but there are a range of factors to consider to try to mitigate the risks of potential claims, and so other options should be explored first. Next slide, please. Okay, so my final topic to talk to you about is compulsory vaccinations. So as many employers consider a full, phased or flexible return to work in the office over the next weeks and months, one key question that many of you may be considering is whether employers can insist upon employees being vaccinated. However, whether this can be done is a complicated issue. In short, it may be possible, but there are plenty of things to consider first. So understandably, employers may be keen to ensure that staff are fully vaccinated and to have some kind of proof of full vaccinations. The potential benefits are on the slide. So vaccinations could protect the health and safety of staff, customers, suppliers, clients, or service users. They could help to stop the virus spreading, and they could reduce the effect of staff sickness absence on the business and its operations. In addition, having the information regarding the vaccinations themselves, so whether people are vaccinated or not, could also assist an employer to monitor how many staff have been vaccinated, to assess how vulnerable the workforce could be to a coronavirus infection. So you could monitor staff levels and exposure in that way for an operational perspective. However, although employers may be keen to take advantage of the benefits of compulsory vaccinations and any reporting to that effect, there are some risks in implementing such a policy from both a legal and a practical standpoint. So turning to the practical risks first. So the government's position is that vaccinations are strongly encouraged but not mandatory, save for the care home sector as of the 11th of November 2021. And accordingly, employers need to think really carefully about how they can justify a requirement when it goes beyond that prescribed by the government, and whether there's a more proportionate measure which could be implemented to achieve the same outcome. Secondly, although vaccination is being recommended as a safe and effective way of reducing the chances of suffering from COVID, the data on whether it prevents transmission is still being examined. The government has therefore not suggested that vaccination is a complete substitute for workplace COVID secure measures. And so this may water down any argument by employers that compulsory vaccination is the best and most proportionate way to protect staff and others in the workplace. So the final practical point is that it's clear from the media coverage on vaccination generally and the many protests that I'm sure you've seen taking place over the past months, that the issue of mandatory vaccination is controversial. Accordingly, on a practical level, employers should not ignore the potential reputational harm which could arise from making vaccinations mandatory, as well as the potential impact on recruitment and staff retention. So moving on to the legal risks. Firstly, it's incredibly important for employers to consider their health and safety obligations. If you're minded to introduce a mandatory vaccination requirement, you would need to undertake a detailed risk assessment as to why this is required, rather than just adopting government guidance, and consult with your employees. The risk assessment should also consider what measures you can and should introduce if staff do not agree to be vaccinated. The nature of some workplaces may mean that vaccination as a prerequisite of undertaking particular roles could potentially be justified on health and safety grounds. However, any introduction of mandatory vaccination must be a proportionate way of addressing that risk. Another potential legal risk is exposure to employment tribunal claims. So there are a number of potential discrimination issues. Firstly, if a mandatory vaccination requirement were to be introduced, or if an employee were to be dismissed or treated differently as a consequence of refusing to be vaccinated. There are several protected characteristics which may be engaged here. So firstly, religion or belief. So by way of example, there may be concerns that the vaccine could have been made by animal products, or its development may have involved animal products or testing. In addition, anti-vaccination beliefs could potentially be protected as a philosophical belief. Secondly, disability. So, for example, if an employee has a disability which makes it difficult or dangerous for them to be vaccinated, the mandatory vaccination could put them at a substantial disadvantage. Thirdly, sex, pregnancy and maternity, for example. The Joint Committee on Vaccinations and Immunisations has advised that pregnant and breastfeeding women should be offered the vaccine, as there's been no specific safety concerns related to the vaccination for that group specifically as yet. But more research is still needed, and so pregnant employees, those who are trying to conceive, and those who have recently given birth may be concerned about vaccinations generally. There are also potential issues regarding race and age, as government research indicates that openness to vaccination is disparate among different ethnic groups, and given that some younger employees could still be at a disadvantage if they've not yet been offered their second vaccination. So as to the types of discrimination at hand in these circumstances, there is a risk of claims for direct discrimination, and that would be if you are requiring a particular employee to be vaccinated or by treating them less favourably because they're unvaccinated. And there's no way to justify this other than in respect of age, so that could have potential consequences for the business. In addition, in relation to blanket or wide-reaching compulsory vaccination policies, there is a risk of claims for indirect discrimination, which will be unlawful unless the employer can justify the policy or requirement as a proportionate means of achieving a legitimate aim. Although a legitimate aim could be fairly easy to establish, for example, protecting the health and safety of your staff, proportionality may be tricky given that there are less invasive ways of minimising the risk. Employers who seek to dismiss any employee for refusing to be vaccinated or for not disclosing their vaccination status may also be subject to unfair dismissal claims. So a respondent employer would need to identify and satisfy itself as to the potentially fair reason and process for dismissal to protect itself. In the absence of express contractual rights to require vaccination, that reason is likely to be some other substantial reason. However, in order to rely on such a reason, employers would need to balance the rationale, business and health and safety requirements against the impact on the individual and the reasons for that person's refusal. There are also potential implications from a human rights perspective if mandatory vaccination is considered. It's arguable that such a practice is an unnecessary invasion of a person's right to privacy, particularly where there are less invasive ways to minimise the risk. And employees who refuse to be vaccinated because of their religion or beliefs would be similarly protected potentially. Finally, there are, as you might imagine, also vast data protection consequences for implementing mandatory vaccinations, which Alexia will talk to you about in a few minutes. So next slide, please, Melissa. So we've talked through the advantages and disadvantages of proposing a mandatory vaccination requirement, but even if you have satisfied yourself that your business can justify such a requirement, you need to think about how you would implement it in any event. So given the pandemic and its impact was, to say the least, not anticipated, it's very unlikely that any of your current employment contracts contain any provisions relating to the requirement of vaccinations of any form. Accordingly, you might, if you wish to implement a contractual provision to this effect with your existing employees, need to follow the usual process for proposing a contractual change. So this means you'd need agreement of your employees, or if that could not be achieved, you could unilaterally impose the change or terminate existing contracts and offer re-engagement on the modified terms. As I mentioned earlier in my first topic, there are certainly risks with either of these options, and so you should exercise caution if you wish to try and follow that process. In addition, for any new employees, although the position is slightly easier in that you can just issue a contract at the outset with your new mandatory vaccination wording, this may operate as a disincentive, meaning that it may cause difficulty in actually hiring staff generally. An alternative to a contractual requirement is to introduce a vaccination policy instead. The aim here would be encouragement and support in getting vaccinated rather than making it mandatory, and it could include provisions such as that the employer would provide paid time off for vaccinations or for any vaccination-related side effects. And this is the approach recommended by ACAS guidance. It's a much less invasive option for employers, though of course will not necessarily ensure that your workforce is completely vaccinated. But if you do wish to implement such a policy, we would nevertheless suggest that you do so in consultation with employees, outlining the benefits of vaccination, any data protection implications, as well as listening to any concerns. So, as I mentioned, it is in theory possible to implement a mandatory vaccination requirement, but there are substantive risks in doing so. And so employers should think carefully about their justification for such a process, as well as the potential implications before starting down this path. So that's everything from me. So thank you very much for listening, and I will pass you on to Alexia, who will talk to you a bit more about data protection.
Thanks, Aston. I'm now going to talk about the data protection side of the issues that my colleagues have been discussing this morning. I've actually just spotted that we've received a question about whether employers can ask employees for their vaccination status and how to store it. So hopefully this part of the presentation will address that. So if we can start with the first slide, please. Before you decide to collect your employees' vaccination status, you should be clear about what you are trying to achieve and how recording staff vaccination status will help you achieve this. Your use of this data must be fair, necessary, and relevant for a specific purpose. If you're recording it on a just-in-case basis, or if you can achieve your goals without collecting this data, then you're unlikely to be able to justify collecting it. I've included on the slide some questions that you can consider before you start any processing. Many employers are considering making double jabs or the use of the COVID pass compulsory as an extra safety measure, but there are data protection issues that need to be considered alongside the employment and discrimination issues that my colleagues have just highlighted. So using the COVID pass would be appealing in a number of situations. For example, using them to avoid the need to self-isolate if the employee has come in contact with someone who's tested positive for COVID, as an extra safety measure in settings where staff have to spend prolonged periods of time in close proximity to customers, as part of a gradual reopening of the office, and where employers have decided to implement lateral flow testing for staff and wish to exempt fully vaccinated individuals from any repeat testing policy. The Information Commissioner's Office, or the ICO, has recently published data protection guidance on using the NHS COVID Pass, which we've linked to in the final slide. The ICO guidance explains that it is possible for businesses to use the NHS COVID Pass to allow access to workplaces without processing any data, by choosing not to scan the barcode and by making sure that none of the information is written down or stored in any way. This approach would involve someone simply looking at the pass at the point of entry without using the scanner and without keeping any records. So at this point, we're not processing data, we're outside of the GDPR remit. Now, if staff are denied access, for example, due to an expired COVID pass, it may be more difficult to avoid record keeping in roles where the employee can't return to work from home, although it will be up to the employer to decide how absence is recorded in these circumstances. If the employer chooses to scan the barcode or to create any records of any kind about someone's COVID-19 status, then the employer will be processing special category health data. This means that to comply with data protection law, the employer would need to start by identifying a lawful basis for the processing, which takes us on to the next slide, please. So the first step is to identify the legal basis for collecting the data. Under the UK GDPR, in order to process personal data, you must have a lawful basis for doing so. Where special category data, such as health data, is involved, you need two lawful bases, one from the list in Article 6 of the GDPR and the other from the list in Article 9. You'll need to carefully consider your options and what works best for your organization. But in our experience so far, clients have been relying on legitimate interests as the Article 6 lawful basis. So I'm going to explain a bit about that. So if you're relying on legitimate interests, you have to carry out and document a legitimate interest assessment. This is a three-step risk assessment, which involves the following steps, as you can see on the slide. The first one is the purpose step, which involves identifying a legitimate interest to process this personal data. The second is the necessity test. And as part of this, you must consider if the processing is necessary in order to achieve the legitimate interest. As part of this assessment, you'll need to consider certain points. For example, if you can meet health and safety obligations through any other means, then it won't be necessary. You also need to think about who's going to have access to the information. And the broader that group is, the harder that it will be to prove that the processing is necessary. Is this a proportionate way of achieving your aim? And can you confine the processing of health data to the highest risk roles? So these are just some ideas. And then the third part is the balancing test, which involves considering the data subject's interests, rights, and freedoms, and balancing this against the legitimate interest being pursued. A key consideration here is whether staff would expect you to use their data in this way, or if they would find it intrusive. Next slide, please. You'll now need to choose a lawful basis from the list under Article 9. Here we've included the two common lawful bases that we've been seeing organizations rely on. If you're relying on the employment condition, you must be able to justify why processing of this specific data is necessary. It has to be a reasonable and proportionate way of meeting specific rights or obligations. Some organizations may choose to rely on the public health condition instead of the employment condition. If you're planning on doing this, you have to ensure that a health professional carries out the processing, or that you tell people that you are treating their vaccination status as confidential and you would only disclose it in defined circumstances. The term public interest is not defined, but you need to point to a benefit to the wider public or society as a whole rather than your own interest. This is likely to apply, for example, to employees that need to have close contact with clinically vulnerable individuals. If the interests are actually the needs of the business, then they're unlikely to meet the public interest definition. Next slide, please. So relying on the employment condition that I've just mentioned triggers additional obligations under the Data Protection Act 2018, namely to have an appropriate policy document in place. This is a document that outlines your compliance measures and retention policies for special category data. It doesn't have to take a particular form, but it needs to outline that you're relying on this condition, what your procedures are for complying with each of the UK GDPR principles, your retention and deletion policies, and an indication of the retention period for that specific data. If you have an internal data protection policy, you can simply update it to reflect these points. The appropriate policy document needs to be retained until 6 months after the date you stop the relevant processing, and it must be kept under review and made available to the ICO if they request it. You don't need to have an appropriate policy document in place if you're relying on the public health condition. Another additional consideration that we've put on the slide there is carrying out a data protection impact assessment, otherwise known as a DPIA. This sets out the proposed ways that data will be processed, the risks to the data subjects, for example, the risk that they will be discriminated against, and the ways in which such risks will be mitigated. For example, limiting the number of people who have access to the record, only keeping records for as long as they are necessary, and complying with the other principles. Remember that you'll need to carry this out before you start the processing. Another one is updating your employee privacy policy. So let your staff know why their information is being processed, how the information will be stored, how long it will be retained for, and who will be able to access it. This will also involve complying with your transparency obligations under the UK GDPR. You also need to comply with the other principles, and data minimization in particular will be important here. So you need to ensure that the data you're collecting is adequate, so it's enough to properly fulfill your stated purpose. It has to be relevant, so it needs to have a rational link to that purpose, and it must be limited to what is necessary, so don't hold more than you need for that purpose. Finally, it's worth flagging that even if employers aren't planning on introducing compulsory vaccination or using the NHS pass, they may still end up needing to process employee COVID data in other ways. So the points I've just mentioned could have a wider application. We'd therefore recommend that you consider whether you will need to process employees' special category data, and if so, to think about whether you need to carry out any of the above actions. particularly a DPIA or updating the staff privacy policy. Next slide, please. So in this slide, we've included links to the ICO's website and the guidance that I've referenced in this presentation. I believe we'll now move on to the Q&A portion. Thank you.
Well, thanks very much, everyone. We've had some great questions coming through as you've been speaking. As we've just kind of touched on kind of COVID passports and vaccination issues, I'll ask kind of Alexia and Aston about, actually something that I think we've all been kind of looking at quite recently, and it's the question that you touched on, Alexia, about whether you can ask employees about their vaccination status, and how the best way is storing that information. And the question has also said that clients have been asking the employer that when they send staff for client events, they only want staff present who are vaccinated. And I think that's quite similar to some of the circumstances that we've been looking at recently. I mean, what's your kind of, both of you, kind of what's your kind of views on that?
Yeah, absolutely, Nick. It's interesting what the ICO has said, because as we know, the definition of processing is so broad that it captures literally anything you do with data. So even if you have access to it, it's processing. But in this instance, they've said that if you're simply checking the vaccination status, the COVID pass, and you're not actually making a record of it, then it's not processing. So that's one way for employers to be able to check employees' vaccination status. And as you've said, we're seeing this trend of, for example, customers only wanting people who are vaccinated to work for them. So what do you do if your organization is the supplier? How do you manage that? And one of the obvious questions that comes up is, does that mean staff will miss out on certain job opportunities because they can't demonstrate that they've been fully vaccinated for many of the reasons that have been mentioned already in this presentation. So from the data protection side, again, it goes back to the organization identifying the lawful basis. Really, we've been looking at legitimate interests, so identifying the legitimate interests for putting in this procedure and balancing it against their staff's rights and freedoms. And if it looks like the staff's rights are going to override the legitimate interest, then the organization won't be able to rely on that. But if they can think of certain mitigating measures, if they can carry out a DPIA, as I've mentioned, and see how to mitigate those risks, then potentially they would be able to pursue and implement that procedure.
And just to add to that, I think in a similar manner to when you're talking about compulsory vaccinations, it's really important to have a framework in place and to communicate that to your employees. I mean, it's pervasive in all of the issues we've talked about this morning, that preparation and communication are just absolutely your keys to these issues. And I think, considering the most kind of the least invasive way of achieving what you want to do. So, not taking more information than is needed, as Alexia touched on, not storing it for any longer than it is needed, and keeping it as kind of condensed as you can, but also making clear to employees why you need that information, and the implications of that. And I think if you're as transparent as possible, then that's probably going to minimize any potential issues down the road, because I think employees like to know what's going on, and if you're open with them, then that should be as helpful to you as it can be.
Yeah, I think it's helpful towards your business case if you can point to client requests. That's not going to be necessarily a guaranteed justification, but it's the beginnings of a rationale as to why you're asking for this, because there are business demands being placed on you by by your clients and customers. And I think that's helpful, but always taking into account the points that Alexia and Aston have discussed. Just one of the first questions that we received was an interesting one, and I'll kind of pass it over to Laura to have a look at, about whether for those employees who are predominantly home-based, say 3 days at home, 2 days in the office, could they claim travel expenses for their travel into the office? What do you think about that? Because I can see that being a question that employees might raise quite frequently.
Yeah, in this sort of new world. I mean, I think it's probably important to sort of go back to the basics of, the individual contract hasn't changed in the main. If they're doing some kind of flexible working arrangement and they're working part at home, part in the office, then I think there's no basis really for them to be able to claim expenses. If you want to do it as an employer, you can, but I can't sort of see any, any way that they'll be able to sort of, rely on being entitled to sort of claim expenses, because, if you think about it, they're working from home some of the time and saving some costs that way potentially. But yeah, their contract of employment, still exists, and they didn't previously get paid expenses for going into the office. If they're traveling to a different office, then that might be a different concern. But for their usual base, you can have a discussion about it, but I don't think you'll need to be sort of, there's not a requirement for it.
Yeah, and I think HMRC tend to take quite a strict line about whether expenses in those circumstances can be made tax-free, and I suspect that in that type of situation they would probably view the employee having two normal places of work, their home and their kind of general office location, and if there's a regular pattern of working there, then you're probably not going to get the tax exemptions that you might, as Laura, you were saying, if they were traveling to a completely different office, which isn't one that they typically work in. So yeah, I think it's going to be, in those circumstances, hard for the employee and potentially hard for the employer to pay those expenses tax-free. And we've just had a question about the implications of suspension with and without pay if employees are returning to work. Aston, what do you think about, if someone is refusing to come back, could you suspend them? What are the kind of options there?
I think realistically, as I mentioned earlier, the first thing to do is to work out why they're refusing to return. I think it would probably be preemptive to suspend them without finding that information out first. And arguably, if you're suspending them purely for that reason, rather than, for example, to investigate the situation, then it could arguably be construed as being punitive, which could give you issues further down the line. So what I would say is, the first step is to investigate the reason. And potentially explore ways that you can be flexible if the business allows. If that's ultimately not possible after you've followed those steps, then I think that you could potentially explore a disciplinary process. Part of that could involve an investigation, which could allow you to then suspend the employee for that investigation. But I mean, how long that would actually be for? I mean, how much more information would you need in that investigation, and therefore what would be the justification for it? So I think it's definitely something you can consider, but I think about the logistics and the sensibleness of that requirement, and make sure you've got all the information you need first, rather than kind of jumping to an action.
Absolutely, no, I completely agree. And what about those employees who have taken another job because they've been on furlough for so long, and now they're saying that they can't come back to work because they've got another job in the meantime?
Well, I think that would kind of depend, really. I suppose if they've gone off to a new job and they're completely refusing to come back at all, then arguably once you've kind of got that information from them, you could consider that to be a resignation. But if it's a situation where they've got another job and so they're only available for certain periods of time and they're refusing to come in their otherwise normal working hours, then provided you've got, again, all of the information available to you, you may institute a disciplinary process on that basis for failure to follow a reasonable instruction. But again, it's about that fact-finding exercise at the beginning, and then ultimately deciding what the kind of path of is best for you.
Yeah, I know kind of quite a lot of employers who've been working with have kind of at the start of any furlough have been saying, well, look, you can take another job whilst you're on furlough, but this is your main one, and your new job shouldn't kind of conflict with any kind of obligations that you have to us. So again, if you've kind of set that out at the start, that might kind of give you a kind of strong position to take action down the line if they are kind of refusing to attend kind of or come back to work in those circumstances. Right, well, I think we've kind of covered a lot of the main questions today, and we've just kind of clocked up to 10 o'clock. So that just leaves me to say thank you very, very much for our brilliant panel today. Laura, Aston, Alexia, you've been fantastic and very clearly taken us through what are kind of pretty complex and difficult issues. I'd also like to thank Melissa and Katie, who've been working tirelessly behind the scenes to make sure that everything has been running smoothly. And I'd also like to say thank you very much to all of you listening and watching at wherever you are and asking such great questions. It's been really, really helpful. As I mentioned, we'll be providing responses to the questions asked today shortly, together with a link to the recording of the webinar. But finally, I just want to say enjoy the rest of your day, and we look forward to seeing you again at our next Pathfinder event. Thank you very much. Goodbye.